Good morning. I welcome you all to the digital learning platform of St. Xavier's College, Jaipur. Myself, Dr. Salim Khan from the Department of Business Administration, St. Xavier's College, Jaipur. Today, we are going to learn about the Indian Contract Act 1872. Before going to the Indian Contract Act, we should also know that why it is so important in the business to learn about the contract. So, before moving to that, we learn certain terms. The first term which we plan to learn is the law. What are the law? Law are the rules that developed by the government in order to provide the balance in the society and the protection to its citizens. So it's very important everyone should follow the rules and regulation that developed by the government or the legislation. If we are not following this law, there may be two consequences. Either you are punished or either you are giving the penalty to the government. So the very basic example of this I will give you. Like the helmet is compulsory to drive a two-wheelers. If you're not wearing an helmet and the police people caught you, what you have to do? Either you pay the penalty or there is the imprisonment. So both the case, sometime both the things will happen, sometime one thing will be happen. So to avoid this, we should have to follow the rules and regulations. The second thing, what is ethics? Ethics are the guide personal conduct based on the moral principle that what is right, what is wrong. If you don't follow the ethics, you will get the boycott from the society. So the major difference between these two terms, first we have to understand the law are the rules that is developed by the government and everyone should has to follow, while in case of ethics, that is the guide, that personal conduct based on your moral principle, what is right, what is wrong. If you don't follow, you will find that you will get the social boycott. So now the little history about this Indian Contract Act. So Indian Contract Act came into the force on 1st September 1872. The act is applicable to whole of the India and it contained 266 sections. Now moving further, we have to learn about this term, that is Latin term, ignorantia juris non exequens. Ignorance of law is not an excuse. If somebody caught you and you are saying that I'm not aware about this law, I'm not aware, no, it's not an excuse. So ignorance of law is not an excuse. The same example I took, that the police people caught you at a traffic light, that means you have to pay the penalty. You cannot say that I belong to a village so I don't know, and in my village the wearing of helmet is not compulsory. So that is ignorantia juris non exequat, that is ignorance of law is not an excuse. Moving further, what is contract? Now we understand the basic of the law, the basic of the ethics, and now we understand the contract as per section 2H of Indian Contract Act 1872. So how they define it? The agreement enforceable by law is contract. So there should be an agreement and its enforceability by law is what the contract. So the contract constitutes these two things. There should be an agreement and there should be enforceability by law. Then it becomes the contract. What is agreement? We already heard about agreement and its enforceability. So I will explain you what is the agreement. According to section 2E of Indian Contract Act 1872, agreement is a promise, or we can say set of promise. In general term, if we define the contract, agreement and its enforceability by law. So agreement is what? There should be an offer or the proposal, its acceptance plus the legal consideration. I will give an example. I wish to sell my laptop for 25,000 rupees. I will give an offer to my friend that if you wish to purchase, the consideration is 25,000. He accept the terms and conditions. That means I make an offer, he gives his acceptance with certain consideration, and in this case the consideration is 25,000. So it becomes the agreement, and when it is enforceability by law, it becomes a contract. So now the definition of contract. Contract is defined as an agreement enforceable by law. According to this element, the contract is an agreement creating and defining the obligation between the two parties. That means the same case, I take an example where I offer my laptop to sale for 25,000 rupees as in consideration. So what I have to hand it over? I have to hand it over my friend, maybe the name, take an example, the party B. I am the party A. So I handed over the laptop job to that particular person, and in return he has the obligation to pay me 25,000. So this is a contract is agreement creating and defining obligations between the two parties. Okay, so the agreement as per section 2E of Indian Contract Act, every promise or a set of promise forming the consideration for each others, that is what the agreement. Now we're talking about all the essentials element which is given in section 10 of Indian Contract Act. So these are the essentials element. If these elements are missing, the contract is null and void. So we discuss one by one. So the agreement become enforceable by law if it satisfied all the essentials element which is given in section 10 of Indian Contract Act 1872. There should be at least two parties. You cannot make contract with yourself. There should be a proper offer and its acceptance. Then it becomes an agreement. Intention to create legal relationship. Contractual capacity, that the person who enter into the contract should be minor, he is not of unsound mind, and is not disqualified by any land of law. Concern or consensus, we also call this ad idem, that is agree upon the same thing in the same manner. The concern which we take, it should be free. Lawful consideration, the consideration should be lawful, the object should be lawful. Not declared to be illegal or a void. Certainty of meaning, possibility of performance, necessary legal formality, or you can say the compliance related to the legal formality. So thank you. We discuss in this class regarding all the essentials element of invalid contract.